Thank you so much and welcome to Chesapeake Public Schools Family Empowerment Webinar. My name is Laura Lerf and I'm one of the Family and Community Engagement Specialists. Our office, which is part of the Department of Engagement, aims to build meaningful partnerships that inspire, engage, and empower families, educators, and community organizations to support the initiatives of Chesapeake Public Schools. We are typically available Monday through Friday from 8 a.m. to 4 p.m. You can reach us at our main phone line, 757-482-5923, or via email at face, FACE, at cpschools.com. Thank you for joining us tonight, and we look forward to working together to strengthen our community and support our students. Our goal is to provide families with valuable webinars, events, and information to empower them in the educational setting. Please take a moment to scan the QR code, which will give you access to our Peak Parent University. This catalog will provide you with monthly events or webinars, including descriptions, times, and locations. On the screen, we have listed just a few of our upcoming events. Please use the Peak Parent University for more information. We will be recording tonight's webinar to share on our YouTube channel. Please note that the chat feature and video have been disabled for this session. If you have any questions, feel free to use the Q&A box located at the bottom of the screen. At this time, I will turn the program over to Dr. Frankie Dampier, Transition Specialist for Chesapeake Public Schools, who will talk about Chesapeake Public Schools transition services and who will introduce tonight's expert panelists.
Good evening, and thank you for joining us as we're going to have the opportunity to provide a very valuable parent workshop for you this evening.
Frankie, you went on mute on accident, I think.
Sorry. I am one of 3 transition specialists who are currently serving Chesapeake Public Schools. I also have the pleasure of introducing Sharon Willis, who is one of our other transition specialists who are with us this evening. Thank you. And then we have Miss Regina Stowe, who is not able to be with us tonight, but she is another one of our transition specialists. Our information is provided for you this evening, or you can reach us by calling the Department of Exceptional Learning, and they will certainly get you in contact with one of us. We're, again, very happy to be here this evening. We are very happy to have with us Miss Shannon Lehman-Pecoraro. She is a practicing attorney in the Commonwealth of Virginia. She is a special needs attorney who specializes in elder law, estate and trust administration, asset protection, planning, financial planning, guardianship, and conservatorship. And she is here to do a presentation for us this evening on financial and future planning, which is very important for us. So we are very grateful to have her here to present this to us this evening. So again, let me present Ms. Shannon Lehman-Pecoraro.
Thank you, Frankie. Okay, so tonight we are going to talk about legal issues to address when you have a child transitioning into adulthood. And some of these are going to be relevant regardless of whether or not you have a child with a disability or whether or not you have a child that's just getting ready to go off to college. All right, next slide. All right, so what is special needs planning? From my perspective as a certified elder law attorney, I want to look at planning to address long-term disability, whether or not that's just financial, whether or not that's personal care planning, usually involves both. It does involve more than trust. So a lot of times I have families that come in and they are like, I was told that I need a special needs trust. There are multiple types of special needs trust, which we'll talk about in a little bit. But big picture, it involves, do we need a guardianship? Do we need a power of attorney? Those types of things as well. In order to truly get the biggest benefit out of special needs planning, you need to make sure you're working with somebody who understands public benefits law, tax laws, because there's some big tax implications and benefits associated with For instance, leaving qualified money to a child with a disability. And the tax laws pertaining to special needs trusts in particular. When I first meet with a client, one of the first things I ask is, tell me about your kid. It's interesting because the vast majority of my clients will start off with, they have a they are autistic. They have cerebral palsy, whatever the diagnosis may be. And I'm like, that doesn't tell me about your kid. I need to know, yeah, the disability diagnosis is relevant for a lot of different things, but really I want to know, like, what are their limitations? What are their strengths? What do they understand? Do you guys all as a family have a hope that they will join the workforce? Do we want to get them out and involved in community engagement? And ideally, if they had a choice, what would they do? And sometimes if it's like my daughter, that means that they just want to be playing their tablets all day, um, which I do not let her do. But that is what it is. All right, next slide. All right, so for a lot of my families, these are going to be our primary concerns. Number one, planning for what the path to disability looks like. As of right now, we obviously have a lot on a political agenda. And so in some of the Facebook groups that I'm in, there's a lot of discussion about what the impact of Medicaid is going to be, which obviously is a big factor in planning for disability long term. We also sometimes talk about housing options, what's available. We locally do have options that are not necessarily available around the country, which creates additional flexibility for us. How are we going to pay for long-term care, especially in cases where maybe the minor or where the child is receiving additional income or has some sort of windfall? What assistance is available to help support the families? Tax and estate planning, both for the individual and for their families. Fiduciary duties. So this doesn't get covered near as much in presentations, but basically whenever we take on the role as agent under power of attorney or under guardianship, we have duties that if we breach them could result in a lawsuit. And so, understanding that we have these duties and what may cause somebody to be reluctant to take on certain duties if you were to pass. Maintaining public benefit eligibility and then also caregiver support, which I know for a lot of my families is one of the big things is just having an outlet to be able to talk to. Right, next slide. All right, so before we get into kind of the big ticket items in terms of planning, this to me is always one of my most important slides. And because what it does is it actually shows what benefits have some sort of eligibility criteria that is financial in nature, and then what ones are not financial in nature. So when I'm looking at income stream, right, and I have a child that has a disability, depending on the assets of the parents, they may be, and the income of the parents, they may be eligible for SSI before age 18. SSI does not stand for Social Security income. It stands for Supplemental Security Income. I do get that a lot. In our arena, you have SSI, SS, and SSDI. So just so you know, like if you're hearing the acronyms, SSI is designed to be the financial need program. In the event, oh, was there a question? Oh, I thought I heard something. So in the event that a child is ineligible prior to age 18, the application at age 18 can go in. Once they're 18, they no longer can look at parents' income and assets. And so as a result, the gateway to SSI opens up. One of the things that I talk to about my families is the long-term impact of applying for SSI. A lot of families say, well, I don't necessarily need the money right now. I just need to make sure that that my child's taken care of whenever I pass. The biggest issue is that if a child is diagnosed with a disability under the Social Security Administration, prior to age 22, they will actually latch into your work record, which then brings us into the not based on financial needs test. So they will actually receive survivor benefits based off of your work record whenever you either retire, if you became disabled yourself, or if you die. If you're still alive, they get to collect up to 50% of your Social Security, and at your death, they get to collect up to 75%. So that's a big latch in where they can where they can build onto your disability and your work income to be able to maintain themselves long term. It is important, and I know that there's some legislation. I actually leave tomorrow to go to DC to work on some of the advocacy issues that we have facing our families. But I know one of the issues is the Marriage Fairness Act. And it's always important for my families to understand that when you have a child with a disability, as of right now, the way the law currently stands, is that a marriage will actually sever their right to your benefits because they are no longer your dependent under the way the law currently reads. And so, you know, I am one to always advocate for having that autonomy and having, you know, normal family relationships that we all, you know, hold dear. But that is one area where I know my families need to be really cautious of. So a lot of times it's civil ceremonies, stuff like that. Obviously, the Medicaid program is both income and asset tested for most of the benefits. In particular, what we talk about is the waiver, which we'll get down to the bottom. There is what's called a veterans pension benefit that is also available for veterans. This is not the compensation program that most people think of. So most people know about the VA disability program, whereby you were injured during your service time, and as a result, you get paid. The veterans pension is actually designed to compensate individuals who do not have a service-connected disability, but they now have some medical needs. There's other assistance such as food stamps and housing subsidies, Section 8, either that or HUD housing. Legal aid is available, but I think when I look at all of this stuff, yeah, the SSI and the latch into SSDI is super important long-term, but the waiver benefits, if we were going to be looking at something, is the most important benefit because that is what will help support an individual when they have phased out of school and or when parents are no longer able to be able to provide just the basic support that they always have. If you are military, the other thing is the survivor benefit plan to look out for. The survivor benefit plan, or SBP, is actually the military retirement. There you can elect a dependent child benefit where they can collect 70 or 55% of your military retirement whenever you pass. There are special tools that we have to use in order to not disrupt some of the other needs tested benefits, but that is a benefit that's also available. All right, next slide. All right, so let's start basic, just your basic estate planning tools. So once a child turns age 18, the most important thing is trying to figure out how are we going to continue to make decisions for them, or are they going to make them themselves? Even if you have a child that is going to make their decisions themselves, one of the big things is to have that some sort of support arrangement in place. So a lot of my families, this looks like a power of attorney or an advanced medical directive. And this will allow family to help somebody make a decision, or they can actually make the decision. However, it does not prohibit the individual from making decisions themselves. We do have supported decision-making arrangements now in Virginia. I do preface that they are not decision-making tools. They are merely designed to support an individual. And so like if they need you to support them to go inside of a meeting, you would be able to go, you know, go into the meeting and help support them. However, under our law, it specifically says a supported decision-making arrangement does not grant an individual the right to make decisions for somebody else. So there is, I don't want to say it's a gap, but it doesn't have as much meat on it as what the powers of attorney and advance directive does. Fundamentally, in order to do those two documents, an individual needs to understand the nature and effect of what they're signing. And so what that means is they need to understand the powers that are being granted to somebody else. In the event they do not have the ability to understand that, and this is one of the things that I normally pull out in my consults is, you know, would they understand this? Would they understand that this document gives mom and dad the authority to manage their money or make their medical decisions like they always have? If they're not able to understand, then what we would have to look at is guardianship and conservatorship. As a true special needs practitioner, I do understand that guardianship and conservatorship is a course of last resort. And that it should only be done in the event that it truly meets the needs of the individual. I often tell people it is not my decision, especially in the gray areas. So like I have a lot of families where their children kind of fit into the gray area, where we could probably do the power of attorney. However, they feel like their child wants to go out and work and they're afraid they might get exploited or whatever. And so they do decide to go the guardianship and conservatorship route because they feel like they need that extra level of protection. Other things that we look at, so other things that we look at for the estate planning tools or trusts. So this could be just a basic revocable living trust, but in most cases for my special needs families, this would actually be a special needs trust of some sort, and we'll get into the different types. We've already kind of briefly touched on the military SBP. This also includes child support. And so, a lot of people overlook the fact that child support is actually the child's income. It is not the parent's income. And so when we're looking at public benefits, child support can actually really disrupt the apple cart. We normally have to, after age 18, we go back to court and get a modification of the child support order to extend beyond age 18, but then also direct it into a special needs trust. So that way the income from the child support isn't prohibiting getting SSI. The child support issue is obviously a touchy one. Some people do not want to go beyond after age 18. So it's one of those things that we always have to open up, so I can't do much about it. One of the other important things to note is that technically when you're calculating child support, you cannot use SSI to offset the amount due by the other parent. And the concept is that because the parent didn't pay in for SSI, right? It's a needs tested benefit, not something that it's not like SSDI, or it's not like the survivor benefit or the dependent benefit. What happens is that they basically say you didn't pay for this, so you need to continue to pay the full amount of child support. That can switch whenever you now are getting the different benefits. While I'm on SSI and SSDI, there is a question about does applying for SSI after age 22 limit the percentage of death benefit? It will actually prohibit somebody from being able to collect under your work record altogether. There are ways potentially that somebody can go back to say like, no, they were disabled to age 22, or, at age 22, we just didn't apply. But that is a very sticky situation. And I have seen it be very unsuccessful multiple times. So as a result, my best recommendation is always to make sure that you are applying as soon as what you can so that they're latched in under your work record, because it is a all or nothing benefit. And there's another little tricky thing that happens too, is like if you're maxing out on SSI, technically whenever you pass, that 75% actually goes over the 300% SSI limits. And what happens then is that technically the income is over our Medicaid waiver income limitations. Virginia does have a 2-year trial period to basically ignore Social Security income for waiver eligibility right now, thanks to one of my good friends in the community who is another lawyer but has a son with autism. And he had realized that this was going to be an issue and was going to take his early, which would reduce his benefit and therefore should have reduced his son's benefit. However, the rule is that survivor benefits for a dependent child do not get reduced just because you claimed yours early. They will still get the full percentage of whatever your full retirement age benefit was. So that's a big thing that we're kind of monitoring right now in the community. Funding, how are we going to fund everything that's needed? A lot of times, housing becomes kind of the primary issue, and a lot of people want to keep the house intact for the individual with the disability. We do talk about whether or not it should be a split between all the kids for the house, whether or not we want to say that it only belongs to the child with a disability. People can move in, help support, but at the end of the day, making sure that the house can't otherwise be sold for the benefit of another beneficiary, which would detrimentally impact the child with a disability. So we kind of walk through that stuff. But then we also have to make sure that, is there enough money here? Or, how are we going to fund the trust to be able to maintain the house, all the care that may be needed, whatever the case may be. And so a lot of times we might look at life insurance for something like that, just to make sure that there's an extra cushion for that one particular child. I do often tell people whenever we're looking at death planning, it does not, there's no set fixed percentage, or there's no right or wrong answer on how much you leave one kid versus another. And so I do see parents make a decision where they still want all their kids treated equally, regardless of disability status. I have some who say, well, the other ones can work, this one doesn't, so they are going to get everything. And we have some parents on the complete opposite end of the spectrum that says, well, they're currently in a supported living arrangement. Medicaid is taking care of everything. I don't really need to leave them a whole bunch. So maybe we'll give them 10%, maybe we'll leave them nothing. And because they're going to get this increase in income, and leave it all to the other kid. And if they need something, I know that kid will take care of them. So there is no right or wrong answer whenever we're planning out these things too. All right, next slide. All right. Surrogate decision making. So I've already kind of touched on this, but this is basically so that you can stand in the shoes of somebody else and make decisions. So usually we're looking at power of attorney and advance directive, or guardianship and conservatorship. The difference is capacity. So when we are creating powers of attorney and advance directive, there is a presumption of capacity, because at age 18, we are presumed to have such capacity. In a guardianship and conservatorship, there's actually a judicial determination of incapacity. So the court is determining that you no longer have the capacity to make your own decisions. Under the power of attorney, you get to decide who you want to make the decision for you. So they're your agent. Whereas in the guardianship and conservatorship, the only way to get it done is by the court deciding who should make the decision. And whenever I talk about both of these things, as of right now, we're talking about the individual transitioning into age 18, and these are things that we need to look at. But it's also important for mom and dad to have these things. Anybody who may later want to step in and help. I mean, anybody over the age of 18 should decide. We should be deciding: are we getting a power of attorney or a guardianship? And that doesn't change. I am doing guardianships on 80-year-olds on a regular basis, and the process is not different. It is not different if you are turning 18 versus if you are already 80. It is the same exact process we have to go through, and it's not fun. Under a power of attorney and advance directive, we don't have any accountings. You can require them, but generally our families are like, no, we want it outside of the court. We want to make sure that like our family's just getting along, they'll be fine. In the conservatorship arena, by statute, you have to account for what you have done with every penny of your ward's money. And so there is what's called a commissioner of accounts that will oversee the actions that have been taken by you. Under the power of attorney and advance directive, there's no what's called surety bond, but there is in the guardian and conservatorship arena. Well, there's a bond. Usually the guardianship is $1,000 without surety, but the conservatorship, you've got to post surety. And what is that? It's an insurance policy that essentially says that if you mess up, they will put the money back in your child's bank account, but then they're going to come after you for the money that they had to pay out. In both cases, we can actually look at a representative payee. It is important to understand that a representative payee is separate and apart from either one of these two creatures. I was actually just fighting with opposing counsel earlier today because in a guardianship order, he wanted to put in that the court appointed a representative payee. And I said, a state court, by its very nature, has no authority to control anything at the federal level. And I had to give a basic civics lesson about, federal and state government, anything not expressly reserved for the federal government or anything, not expressly reserved for federal is a responsibility of the state. And since the guardianship is a state creature, it will not control things like Social Security, DFAST payments. If you're getting OPM payments, they have their own processes, and that's what the representative payee process is these federal government entities will actually appoint somebody to handle whatever it is under that federal program. All right, next slide. All right, capacity, I have touched upon this already, but it's the nature and consequences or the nature and effect of the document. A lot of times when I am in a gray area to determine where there is capacity, I want to assess it outside of the presence of other family members. And whenever I do this, understanding the community that I work in, I will normally have the family come in, kind of get warmed up before I say, okay, I need to, have a discussion to make sure that they can answer the questions. The big reason why, and a lot of times too, I do prep the parents as to like the things that I'm going to be asking, like for instance, about, in the event of a persistent vegetative state, do you want life prolonging measures, those types of things? Because those are very sensitive subjects, I think, especially for 18-year-olds. None of us want to talk about it, but 18-year-olds may not, like, we're still untouchable, right? We're invincible. Nothing's going to happen to us. But I will try to meet with the individual outside of the presence of the family so that they're not deferring to what the family is saying. And we have to do that as attorneys because we have to make sure that the decisions that are being made are the individual's specific decisions, and that yes, they want both mom and dad to act. Do they just want mom? Do they want their sister to, inherit everything? Whatever the case may be. We do document capacity, and so we do this in two ways. Number one, I make, and trust me, there are cases where I have kids that have Down syndrome or cerebral palsy who have a full understanding of everything that I'm talking about. In those cases, I am not necessarily putting in a memorandum stating like exactly what transpired in terms of a capacity memorandum. But in those, in particular, gray areas, we want to document where it was so that we can pull that in the event anybody ever questions. The other thing that we do is we get two witnesses and a notary who are asserting that, yes, they understood what they were doing whenever they signed it. When we are in doubt, and I have to do this quite a bit for my senior community, I will obtain a doctor's note that basically says like, yes, they have the ability to understand these documents. Because at the end of the day, I'm a lawyer. I am not a medical professional, although sometimes I feel like I do play one on TV. There is another question. Okay, yes, I'll go ahead and answer it now. So, because we're on the guardianship conservatorship arena, the most important thing to do before a child turns 18 is to start assessing, before we start getting into this, the number one thing is to determine whether or not you are going to qualify for the Medicaid waiver. That thing takes forever. I tell clients when they come in, it could be 20 years before you get that. So getting your child on the Medicaid waiver wait list, I want you to do it the second they're born because it's going to take forever. And so that's, to me, actually the most important thing. The next most important thing as they're turning 18 and we start looking at this stuff is really determining, are we going to need a power of attorney and advance directive? If so, I can't get that signed until 18, but we can start getting everything drafted. And sometimes on their 18th birthday, they actually show up at my office, and sometimes I have cupcakes so that we can sign and celebrate their 18th birthday that way. And if they don't, and you know that we're going to have to look at a guardianship conservatorship, I can file that at 17 and a half. Some courts take time to get into. So for instance, it's either Hampton or Newport News, and I mix them both because I'm on this side of the water so much. I mix up Hampton and Newport News all the time. I think it's Hampton. But just to get into probate to qualify after the court has appointed you, sometimes it can take 4 months, 6 months to get in there. And so we don't want that gap to happen after age 18 of not being able to make certain medical decisions in the event we don't have the guardianship. So that is what I would say from kind of what we're talking about today is the most important thing as you're planning for age 18. All right, next. All right, so when we're looking at, I always like to pull this up because, and I've got the Q&A up. When we're looking at the legal definition of incapacity, this is it, okay? And so a lot of times I have to step people back when we're talking about guardianship because I will have kids that come in and they say, my dad's buying Bitcoin and I just don't think that that's a good investment. He's got no clue what he's doing with cryptocurrency. right? Like, I don't approve. That is not a lack of capacity. Essentially, when we're trying to figure out whether or not somebody is incapacitated such that a guardian and conservator can be appointed, we're trying to figure out whether or not their capacity is such that they lack the ability to make their own basic healthcare and safety decisions without the protection of the guardian, or manage property and financial affairs without the conservator. And so that's the definition. Just because we don't like the decision, we all have the right to make bad decisions. If we didn't have that right, there would be very few bankruptcy attorneys out there doing their legal work. All right, I'll get to that in a minute. All right, next slide. All right, so the guardianship conservatorship, I've touched upon the incapacity piece. There are two different components here, similar to the power of attorney and the advance directive. One is controlling the person, the other one is controlling the estate. Usually whenever I do the initiation of these things, I do both at the same time. And that's because nobody wants to pay me twice to do the same process twice. Just because we didn't think something through. And I do like indicate to the families, you know, what that means for them long term. But big picture, the guardian is the person who's going to choose where the individual is going to live. What course of medical treatment are they going to get? What education are they going to receive? Are they going to stop going at age 18, or are they going to continue on until, you know, they phase out at, 21? So I don't know if it's 21 or 22. I think it depends on where they fall in the school year. And then, employment, are they going to go get a job? Are we going to go volunteer maybe at the SPC around the corner just to give them some activity during the day? And then conservatorship is strictly financial. And so that's where a lot of the court oversight remains over things. All right, next slide. All right. Some new things that have happened under the code here recently is that now in the petition, we do have to identify the PCP, and the guardian ad litem is supposed to try to make contact with them. We do have to get an actual evaluation report. Sometimes I get letters from doctors or, clients are trying to be helpful in getting this stuff. There is a standard form that we use and get out. If I'm doing something over on the Eastern Shore, they have their own form that I've got to use. So it's not like standard in the sense that the Commonwealth of Virginia doesn't give it to us, but it's pretty commonplace form to detail in somebody's right to vote, somebody's right to carry a firearm, those types of things, because we could essentially be stripping away some civil liberties there. And I already said the GAL must attempt to consult with the doctors to make sure that, they understand the medical information. All right, next slide. All right, so this was just about the surrogate decision-making piece today. There are other times where I do talk about special needs trusts, in particular, the 3 types, just to kind of go over them real quick for you, because I know that is often a hot topic, but it's not really a topic that necessarily impacts the individual transitioning into age 18. Under the special needs trust, there's actually 3 major types. So you have your first party trust, which is going to be the trust that is set up with an individual's own assets. So if grandma and grandpa kept giving kid money over the course of 10 years, whatever, and it's amassed to over $2,000, that's a problem for SSI and Medicaid. And so we can use what's called a first party special needs trust, get that set up and move the assets into that. A lot of people don't like that trust as much because I tell people it's the you can't have your cake and eat it too rule trust. Essentially, the most important or the most expensive part of having a disability is often those waiver programs. There is some statistics, and I do have some slides that I sometimes use that talk about it's about 15% of the population is on what's called ABD Medicaid, which is your age blind disabled Medicaid. Those programs actually eat up, or that 15% of the population actually eats up 75 to 85% of total Medicaid dollars spent in the Commonwealth of Virginia. And so when we look at the frustrations associated with the Medicaid waiver wait lists and things like that, that's really the driving force behind it, is that the programs to have a one-on-one attendant inside the home, for example, is a very expensive program. And so that is why we have the overall wait list. But that's why the special needs trust says that you can't, essentially it has what's called a Medicaid payback that says at the death of the beneficiary, any money remaining inside this trust will actually go to Medicaid to repay back whatever Medicaid dollars they paid for on behalf of that individual. If there is surplus after paying that lien, then that will go to the family. But the vast majority of the trusts I see, it ends up just repaying back Medicaid. Then you have what's called the third party trust, and this is for like inheritances or like things that haven't vested down to an individual, in their own name. And that trust there is no Medicaid payback because essentially you have no legal obligation to leave your child anything. The only person we have to leave stuff to is our spouse in Virginia. And so you can put it in this trust that's designed to supplement whatever they need. It's very specific language that has to go in there. And if you're working with a practitioner, I have just reviewed documents earlier this week where they worked with somebody in a different state who doesn't do special needs planning, and I have to redo everything. And so that's not a fun, it's not fun news to deliver, but at the same time too, they said, no, we want to go ahead and clean it up because we don't want our child to be detrimentally impacted. And then the third type can actually be a first party or a third party trust, but what it is, it's actually called a pooled trust. And so for my families who say, I don't want brother and sister to have to manage the financial piece of it. This is huge in my mental health, arena. Because like I have a sister with bipolar disorder and with that self-medication issue, and she's got PTSD from some decisions she's made.
So this was the conclusion of her presentation. I'm going to go ahead and start to wrap it up, and we will see if she comes back on. So we thank you very much for taking the time to learn more about future and financial planning for students with disabilities. We hope that you've gained a wealth of knowledge and information. If you have questions pertaining to tonight's webinar, please feel free to contact the Office of Exceptional Learning at 757-434-7600 or about other events hosted by our district. Please scan the QR codes located on the screen, and don't forget to download our app so that you get all of the updated notifications about your child's school and our district. At the end of this webinar, you're going to receive a brief survey, so please take a moment to complete this so that we may know more about your interests. As always, remember, families and communities work better together. And if we can maybe pop up her information one more time on the screen, and that way you can take a picture of her information in case they have questions. All right. And we thank you all so much for joining us this evening. Take care.